Good evening, everyone. We welcome you on this night to our Zoom for over 2 years, twice a month. And we thank you, not just Fifth Baptist, but friends from everywhere for joining into all of our Zooms. And tonight, we'll talk about wills, trusts, and powers of attorney. Let us pray. Eternal God, our Father, we thank you for this day. Thank you for every individual and every home represented on this evening. May we continue to gain knowledge in every aspect of our lives. In the name of Jesus Christ, we pray. Amen.
Amen.
On tonight, we have Andrew Richardson. Before fifth grade, we were friends at Fisher, way before Fisher, a graduate of Purdue University, and his law degree from the College of William and Mary. And as I've told you all in my sermons, if I ever get in trouble, my two best friends are also married to lawyers. So there are 4 people I'm very close to who can get me out of trouble. So we are thankful on tonight that Andrew Richardson, and he will come in his own way.
Thank you, Ricardo. And one of them is a judge now. So yeah, Daryl and I both married well. My wife is also an attorney, practicing immigration law, and our friend Daryl Taylor. I think Daryl actually put his law practice on hold to become a pastor, if I'm not mistaken.
That's true. It's on hold.
It's on hold, and his wife is now sitting on the bench in Loudoun County. So we're very proud of them, and I like to talk about all of these because these were the young men I grew up with. So it was a blessing to be surrounded by all these future pastors who kept me out of trouble. And so, thanks to Ricardo and Daryl and David Talley, whose father was also a pastor. I think I was brought up right and surrounded by a lot of positive men. So Ricardo reached out to me, I think maybe two weeks ago or so, and asked me if I would be willing to speak on a topic that, some people find difficult to discuss, which is sort of end of life planning, what I call like protecting your house. And you see on the screen, I've shared the screen with you here as a brief outline of what we're going to go over briefly today, and talk about a little bit about wills, trusts, powers of attorney. There are a few other documents as well that I'll also discuss. A little bit about me. I played football at Purdue University. Realized I wasn't going to go to the NFL, so I decided to go to law school. Was accepted into William and Mary, and finished in 1995, and I have been practicing in various areas since that time. For the first 5 years or so, I was actually in Richmond at a law firm, Williams Mullen, down on Cary Street, before I moved to the Northern Virginia area, and then finally settled in DC. So most of the work I do now is in DC, but I have practiced in all 3 jurisdictions over the course of that time. Since that time, I've sort of narrowed my practice to estate-related matters, wills, trust, probate, powers of attorney, guardianship, conservatorship, and all the other different aspects that sort of impact sort of how we live, how we obtain things and manage them, how we protect them, and ultimately how we pass them on to our loved ones, relatives, and friends. So I don't know the crowd that we have here tonight. I'm not sure, how educated anyone is in this area, but if there are questions, please feel free. I'll do my best to answer them. But my goal here is not to give legal advice or bore you to death with a bunch of legal terms, I'd like to share some ideas and about something I think is really important, especially in the Black community, and that is how we can ensure that what we have been blessed with and worked so hard to accumulate is adequately protected and managed. And then when that time comes for us to pass on, those personal items that we cannot take with us can be distributed as we see fit. As many of you know, our community has lost a lot of wealth over the generations for various reasons, not the least of which is failing to plan for how to pass property on to children and to our family members. And we've lost a lot of wealth in our community to the tax man, for example, and really just through neglect and a lack of understanding of how to handle our affairs and what we should do as we pass on. So I start out with wills, trusts, and powers of attorney because I look at those as the three core documents, right, that you should have a general understanding about when you talk about what it is I have, what I want to do with it, how am I going to protect it, how am I going to pass this on to my loved ones, whether it be a spouse, a friend, a significant other, a child, or a parent. So I think we've all heard the term will, right? A will is a legal document whose purpose really is to identify what it is that the person who has passed had at the time of death, and to direct someone to manage that property and see that it is distributed in the way that that person intended. So every state has its different laws specifically about wills, and I won't get into that too much, but I just think the broad stroke is important to understand that the sort of key and core document when you're talking about estate planning is the will. If you have nothing else, but you have a will, at least you have some say-so in how your assets will be handled once you pass. And I like to tell my clients that, once you're gone, and it's no longer your problem. But if you haven't predetermined how those items are going to be handled, they could very well become problems for those you leave behind. So if you want to avoid controversy, if you want to avoid misunderstanding, and maybe infighting among relatives and friends, it's not a bad idea to have a will drafted by an attorney to at least get that on the record so that you can do the minimum to make sure that things are handled the way you want. Now, I don't know how I'm going to, if there are any questions, I'm sure the other administrators here will let me know, and feel free to interrupt if you need to, okay?
Chip, let me ask you,
Mm-hmm.
handwritten wills, are they recognized in Virginia?
I tell you what, I try to tell people that when you get into the nuances of things like holographic wills, wills that are handwritten, it becomes very, very, very intricate. And a lot of times the court will have to determine whether or not that document is valid. Basically, if a person writes the will completely in their own hand, and it's going to be recognized, right, as a will in most places. But whether or not it was written in that person's own hand, that's a legal question, right? And that's something that could be contested. So what I try to tell people is this: those are the types of questions that you want to try to avoid, right? You really want to try to avoid not having your will conform to whatever the state requirements are, okay? And so, most states require, yes, that it's a writing. It's been reduced to writing. There were proper witnesses to the will, and that the person demonstrates certain things. obviously the person needs to demonstrate that they know who they are. They need to demonstrate that they understand what they call the objects of their bounty, understanding what your property is. So if you have a will, if you know you live on Third Street, and in your will you say, well, I live on Fifth Street, then that's going to probably call into question whether or not you were in a sound mind when doing the will. So you want to see if you can at all costs, try to have the will prepared by an attorney who is familiar with how wills are always accepted in your jurisdiction, okay? Because in certain instances, Ricardo, yes, a handwritten will can be accepted, but there are so many ways to slip that up, right, that you really want to try to avoid it.
Oh yeah, I just wanted to get clarity because in this pastoring, I've heard all types of situations.
Right.
Just wanted to get some clarity.
Right. Well, and that's the thing, part of the reason why lawyers are always employed in this area is because there's so many ways that things can be called into question, right? And so if you're not sure, hire a lawyer. And usually if you just want to, retain a lawyer to do a will, it relative to what could go wrong, the cost is negligible. You can find a lawyer to do a will, usually less than $1,000, right? And it wouldn't be a problem. Right? I'm using 1,000 as sort of an elastic number for, a lot of attorneys when they do wills, they also want to do trust and powers of attorney, et cetera. But, if you hire the attorney specifically to do a will, they can't overcharge you for that. Okay. But they can make sure that that will comports to the state requirements. Okay. So I certainly would highly recommend that if anyone endeavors to do it, don't try to do it on your own. I mean, I know that there are, apps and websites now, LegalZoom, it comes to mind, that will allow you to do your own will online. Now, they have a lot of attorneys on staff that help with language and the basics, et cetera. So, are those wills likely to be valid? Probably. I think if you talk to most attorneys who are not affiliated with LegalZoom, they would sort of, have you shy away from those. But certainly those are options out there. And if someone is more comfortable doing LegalZoom than working with an attorney, then, that's better than having nothing. Okay. So if you find a resource out there that's helpful, certainly take advantage of that. The second document that I'm going to talk a little bit about is a trust. And a lot of people talk about trust. Should I have a trust? Or I need to have a trust in place.
Excuse me, Chip. I should have told you, we'll be monitoring the chat room. Got a question in the chat room.
Okay.
What happens when you can't find the original will, but have a copy? Does this cause certain concerns?
Yeah, it can cause concerns because the original will is the best evidence. Okay, I know that if there's a copy of a will, it's got to be an original somewhere, right? Usually, you will have to go to the court and petition the court to accept the copy of a will. Okay, and so it's very important. It's very important that when you do an original will, when you do a will, and if you make copies, to clearly mark which document is the original, which documents are copies, and I think even more importantly, a lot of people, sort of miss this piece. If you do a will, if you go to an attorney, you do a will, they give you the will back. And if the attorney doesn't keep the original, which in Virginia is, not the norm, but it's more common practice in Virginia for attorneys to hold on to that original will. So if you see a will that has the name of an attorney who prepared it, maybe a good idea to call that attorney to see if they have the original will. But you want to make sure that personal representative who's named in the will, the executor, if you will, is aware of the location of the original will. Dead folks can't talk. Okay. And so, once you've done your will, you've done everything that your planning suggested that you should do. The last thing you want to do is have nobody be able to find the original will. And so, yes, a copy of a will can be contested. The original will is the best evidence. And there's, can be a presumption that, if that's a copy, then that's not the last will that the person intended, that the original will may have been destroyed. And there may have been an intent not to have a will. And that's the concern. The concern is, at the time this person passed away, was this the only original will signifying the intent of the testator? And if you have a copy, that's called into question. Okay. We have some more questions in the chat.
That's it for the chat room.
Okay. So trust and powers of attorney. I don't want to bore anybody on the call, but trust and powers of attorney, I think are let's start with powers of attorney. I think the powers of attorney in my practice as I've aged, I've realized that powers of attorney are vital documents, because we especially with COVID, right? You never know when something may befall you, an illness, a disability, an accident, which could take you out of commission and leave you unable to handle your own affairs. If you put a power of attorney in place, and a power of attorney, again, is a legal document, the intent of which is to designate a person to have the authority to act on your behalf in the event that you cannot do so. Okay. And that power of attorney can be very broad. It can be very limited as you see fit. I had a very recent case where a young man about 38 years old started his own business and became very successful and had multiple $1 million government contracts. He fell into a coma and he did not have a power of attorney in place. And he had a business with where he was the sole owner with 15 or so employees. He had draft contracts, and I say draft, they had been signed by the government and were awaiting his signature so that his business could take advantage of those government contracts. And he was in a coma. He had no power of attorney in place. He had not designated anybody to make healthcare decisions for him or to make financial decisions for him. And again, he was in his 30s. The hospitals did recognize, since he had no spouse, had no children, the hospitals did recognize his mother for the healthcare side of things. So they allowed his mother to make decisions on medication, whether to intubate, keep him on life support, et cetera. But when it came to the business, there were no documents. And so we had to go to court. We ended up in court trying to petition the court to allow the court to have the court protect someone who had his best interests in mind. It was not an easy process. It was not an easy process, and it put his business in jeopardy, which put his livelihood in jeopardy. And it also put the livelihood of those 15 employees in jeopardy, because if the business failed, there would be 15 people unemployed. All right, so this is that could have been avoided had he had a power of attorney in place, which identifies someone with the proper authority to maybe handle his financial affairs, conduct his business as he saw fit, et cetera. So not everybody will have that type of situation come up, but it is not unheard of, especially now after the pandemic, being hospitalized for more than 90 days, 120 days. And somebody has to make sure that the grass keeps getting cut, that the bills are paid, that somebody can sign checks, you name it. So the power of attorney, I think now, is probably if not more important than it was before, it's certainly something that seems a little bit more relevant to the common man, if you will, than it did before. It's not just for people who are rich. Okay, the power of attorney is just to make sure that things are still going smoothly. If you can't make that decision and handle those affairs on your own. There are healthcare powers of attorney. If you, for example, have someone you trust with respect to your healthcare and your personal items, you can designate that person as a healthcare power of attorney. And if you have another friend over here who is a math whiz and a business whiz, that person can be designated for the financial affairs. You can do this any number of ways, but putting that document in place just ensures that things go smoothly until you are able to get back on your feet and handle things. With respect to the trust, any questions about that, the powers of attorney? Okay.
This is Beth Morgan. I have a question.
Mm-hmm.
Isn't it true? I don't know if it happens here in the state of Virginia, but if someone has power of attorney, it ceases once the person passes on. Am I correct?
That's right. That's right. So the power of attorney is one of these documents that operates while you're living. And once you pass away, that attorney in fact, which is what that person is called under the power of attorney, loses any authority to act. Okay, so you can have, of course, a will in place, you can have a trust in place, or a living will advanced medical directive in place. So I'm glad you asked that question, because that sort of segues into how does the trust work, or how does a living will advanced medical directive work? And so yeah, let's say you did have a power of attorney in place, and you had a person acting on your behalf, and you pass away. If you had no other document, and then people would be looking for a will. If there's no will, they would then have to open proceedings and designate someone as a personal representative in an intestate proceeding. The trust is what I call like a living legal document, right? So a trust can be put in place while you are alive. It can operate while you are alive. And then once you pass, it can still continue to operate. Okay, so you'll see on late night television, people, advertising, avoid probate, get a trust. It's a little bit more complicated than that. But what the trust does is the trust operates almost like its own legal entity. It can hold title to houses. It can hold title to bank accounts. It can hold title to cars. It can hold title to anything you can hold title to, right? And you can put your assets into a trust, identify a trustee with certain powers and obligations and responsibilities, just like you have. All right. And so what you'll see is people using what is called a revocable living trust. Okay. And what that really means is, okay, I'm alive. But I'm going to put together this trust. I'm going to name myself as the first trustee of this trust. And then I'm going to name someone as a successor trustee in the event that, again, I am no longer able to handle my affairs, or I have passed away. Okay. That trustee, after you have passed away, would have the same rights, authority, and obligations that you had before. And you can identify within the terms of the trust, how you want the trust assets dispersed. Okay. And so what you'll see often is attorneys setting up wills and trusts together. Okay. So when you're thinking about estate planning, one of the things that attorneys always try to do is they try to make sure that 100% of your estate is handled and accounted for as part of the estate planning process. And so if you have a trust and you put your Chevette I'm dating myself because I'm not even sure they still have Chevettes. If you put your Chevette in a trust, and you live for 8 more years, and you've also all of a sudden you've moved up, and now you have a Porsche 911, but you don't ever put that Porsche 911 in the trust, and you pass away, all of a sudden the Chevette is handled per the terms of the trust, but the Porsche is on the outside of the trust. Okay. And so what attorneys try to do with that will, they may put language in the will which takes into account that possibility that, okay, we set up this trust when this person was 67 years old. This person didn't do any new documents, passed away at 87, and accumulated a lot of other property that never made it into the trust. All right. And so the will can then deal with that with pour over language, what we call it. Have those assets come into the trust, and then the trust, through its terms, can dictate how that property is distributed or managed. Okay. So think of it this way: if you have an ongoing business, for example, you may want that business to continue. You may have young children who are too young to step up and take care of the business. You pass away, and these young adults, let's say they're 19 going on 20, and still sowing the wild oats, not quite responsible for handling the reins of the business. If that business is in a trust and there's a trustee assigned who is responsible, he can keep that business running. Those children can still be the beneficiaries of that trust without running the business into the ground. Okay. So the trust is a very flexible document. I mean, you could, there are treatises written on trust. So I don't want to get too far along in the trust, but I just want you to have a basic understanding about that document, and how people say, oh, it helps you avoid probate. What it does is it helps you avoid skipping a beat. So if the trust is in place and you pass away, there's already somebody designated as a trustee with their power and authority to act without you having to go to court initially. Okay. And that's the I think the most beneficial aspect of a trust. And again, they work alongside the powers of attorney. And maybe you don't need both a power of attorney and a trust. It may be overkill, but attorneys like to make sure you're papered up. With respect to the living will and advanced medical directive, so these documents are very, very important. Very, very, very important, because they tell the world how you want to be treated in your most vulnerable time. Okay. And something has befallen you, an illness, a cancer diagnosis, something that, has you in a situation where you are facing the end of your life. And there's a question to be had as to whether you should be kept on life support or whether you should be let to pass on peacefully. Okay. Depending on the family situation, that the answer to that question is not always clear, right? And it is also not always clear which of your friends, significant others, or family members has the authority to talk to the medical professions and make that call. Okay. You have a living will, advanced medical directive, it does that for you. Now, I assume that, coming out of the pandemic, a lot of us have had to have a lot of conversations with doctors and nurses in hospitals recently. And the hospitals are doing a better job of pushing these living wills and advanced medical directives into your hands or into the family members' hands when people get into the hospital, because they want to know, if we get to a situation where we have to intubate and we have to keep this person on life support, whether it be a feeding tube or a breathing tube, how long? If there's no signs of progress, who's going to make the call about what to do with either starting that process or withholding that support? And so these documents, the living will and advanced medical directive, give you the opportunity in advance to think about it and then put into words who you want making that decision on your behalf, and then laying out that decision. Okay. A part of the things I do is, I serve as guardian and conservator for a lot of individuals who have various either disabilities, whether it be mental disabilities or physical disabilities. And I find myself in a situation where I am having to make these calls from time to time. And sometimes I have developed a relationship with a person such that I know what they would want. And sometimes my clients are nonverbal and cannot express what they would want. Those are very, very difficult decisions, very, very difficult decisions to make. And I pray that you never find yourself in that situation where you have to make that decision for someone else. It's very difficult. So if you want to avoid having that trauma fall on some of your children, you can put together a living will or advanced medical directive and designate someone and have a conversation. I don't want to be on a machine for 3 or 4 weeks or forever, and I don't want to be fed through a tube. I would like to just be comfortable and given the minimal amount of care and pain medicine to allow me to go peacefully. Whatever your preference is. There's some people like, no, there's going to be a cure. Go ahead, keep me on that machine until they find out, the next best thing. If I'm there for 3 years, that's the way it is. Whatever it is, whatever's your preference, you can make that known so that people aren't unsure and maybe fighting about that decision. Any questions about that?
Mr. Richardson.
Mm-hmm.
Good evening, sir.
Good evening.
The dual power of attorney, I guess, would that be unlimited scope of what you can do versus if we have to go out and get another power of attorney, such as finances and healthcare? So why should we want to go with just the dual power of attorney and cover everything?
I think I understand what your question is. So whether it's durable or not doesn't really go to the scope of the power of attorney. So let me just say this about a power of attorney. You can put anything in the power of attorney that you choose to, right? So you can make that power of attorney as broad and all-encompassing as you want. So for example, you could say that, through this power of attorney, I give my attorney, in fact, to do all things, relating to my business and finances that I would be able to do, all things without limitation, okay? Or you could make the power of attorney very narrowly focused, in the event that, I'm unable to handle my affairs, I want this attorney, in fact, only dealing with X, Y, and Z of my life, right? And then ABC may be handled by somebody else, okay? So when we talk about the breadth and the scope of a power of attorney, it really depends on what your goals are, okay? So again, and that's sort of the problem with just pulling up a form, right? You pull up a form, power of attorney, you get whatever's in that form. But you should give thought to, your particular circumstances. Everybody on this call has a different financial situation. Everybody here has a different familial situation. And so the power of attorney should really be tailored to what it is that you want done. Now, when we talk about durable power of attorney, the difference between durable and a regular power of attorney is just that the durable kicks in when you are incapacitated. So for example, let's say I go to California and I'm fine, but I'm going to leave a power of attorney with my assistant so that she can do certain things back here in DC while I'm in California, right? That's just a regular power of attorney, that's fine. But if it's not durable, if all of a sudden I've lost my capacity to make decisions, then that calls into question whether or not she still has the authority, okay? So we usually make a power of attorney durable in the event we're thinking that we're going to have some type of incapacity. And when I think of incapacity, I think of a person who is unable to manage and understand their own affairs, okay? You can litigate that, and it's not always clear. And sometimes people put in powers of attorney language to the effect that, this power of attorney becomes durable in the event that two doctors say that I'm incapacitated, or one doctor says that I'm incapacitated. Again, those are sort of nuances that you can get into when preparing the document. But I just want people to understand that you can make the attorney in fact, who is the person in the power of attorney, as powerful or as weak as you need. And you can also limit that power of attorney. So again, if I'm going to California and I want to do a power of attorney that has a limited scope, there's nothing wrong with putting in the power of attorney. This power of attorney shall terminate on X date. You can do that, right? So these are very flexible documents. But for the durable power of attorney, what we're doing is we're anticipating that should the person who did the power of attorney all of a sudden lose capacity, that power of attorney remains in place. Now, why is that a question? Why are we using this durable? Because the way the law is developed, you assume that the person who made the power of attorney is there to explain himself. Okay, so I'm in California. Yes, I left her a power of attorney to do these things because I can't do them myself. She can sign these documents. Okay, fine. But if I'm in a coma and the power of attorney is not durable, someone could look at that power of attorney and say, I'm not sure you have proper authority because he's no longer capacitated. I'm not sure that he would want this power of attorney to continue. So we want to make it durable so that it's, think of it as strong, right? Strong enough to survive your incapacity, okay? So it has nothing to do with how much power, how much authority you give that person. You can give that person as little or as much authority as you want in the power of attorney.
Excellent. Thank you very much.
Attorney Richardson.
Yes.
During your first 20 minutes, you were talking quite a bit about wills, and several times during your discussion, you used the word probate.
Mm-hmm.
Would you define probate from a legal or an attorney's definition?
Yeah, I mean, in its easiest terms, basically, probate is the court process, okay? Probate is the court process of recognizing that someone has passed, that this person had an estate, and that this estate is going to be distributed in a certain manner, okay? And that's through the court process, okay? And so probate is going to be different for everybody because, again, everybody's estate is different, okay? If you die owning 9 pieces of property, 2 businesses, 3 cars, and you get 3 ex-wives and a girlfriend and 6 children, and then your spouse had another child, and there was another child who predeceased you, that probate is going to look very different from a husband and wife who've been married for 50 years and had only 1 child, okay? So the probate is just the process of acknowledging that a person has passed, putting that on record, and letting the world know that their estate will be distributed, okay? And that's as simple as it gets. But like I said, probate, whether or not it's complicated, depends on your own personal situation, okay?
Yes, sir. Thank you.
Okay.
Chip got a question in the chat room.
Okay.
You have a durable power of attorney that includes a medical clause.
Mm-hmm.
Do you also need a written medical directive document?
Well, yes and no. And I say yes and no, I hate to do that. It depends on what the document says. Okay, so I don't exactly know what the document says, but let's assume that you have a durable power of attorney. In the medical clause, it identifies a person to make sort of healthcare decisions. Okay, whether or not the document also says what that decision is, I don't know. So again, what I was trying to get you guys to understand is that with the living will, the advanced medical directive, you are making that decision in advance. Okay, you are making the decision in advance. You're even taking it out of the hands of the power of attorney. Okay, so for example, again, let's just say we pull the plug or we keep it plugged in, right? To keep it as simple as possible, right? If I make that decision in writing in my advanced medical directive, you know, if a situation arises and I need to be on life support where I cannot eat or breathe on my own, I want all such life-saving measures withdrawn. You put that in writing. If you have a power of attorney naming somebody who is your healthcare power of attorney, that person needs to follow the advanced medical directive. Okay. If you don't have an advanced medical directive and you're not sure, right? So that healthcare power of attorney is not sure, they do have the authority to make the decision. Okay. Unless you've limited in the power of attorney. So again, I don't want to get into legal advice about a particular power of attorney that somebody may have right now on their desk, because these things can be written any number of ways. Okay, any number of ways. But the way the advanced medical directive is supposed to work, it is a written recitation of your decision on what is to be done end of life in the event that you have to be artificially either fed or kept alive. Okay, so that document should stand. It can stand on its own. Okay. Does that answer the question?
That was the question in the chat room. I didn't see where the person said it did not, you did not answer their question, but that was their question.
Yeah, so I just want, again, I want to make sure, because, you know, people don't like to have too many documents. You know, you got a power of attorney and it has a health care clause. I interpret that to mean that power of attorney also gives the person, the attorney in fact, the right to make healthcare decisions, right? And
They just responded, you answered. I just saw it.
Right. So that's it. So basically, if you want to tell, yes, I'm giving you the healthcare decision, but this is the decision I want you to make. That's what the advanced medical directive does. I want you to do it, but this is what you're going to do. Okay. So that's powers of attorney. And yeah, and I do have, for the gentleman who asked about probate, I'm putting on your screen here some things to think about with probate. Probate is different depending on the state. It's a court process. Court scrutiny just means that the court is going to look at the documents. So for example, if you have a will and you submit a will to the court and there's some defects with that will, the court, you know, may bring that to the attention of the people submitting it. So the court is responsible for making sure that the probate process in that state is handled appropriately and in accordance with statutes, right? I put court requirements and filings and costs because there's a cost to probate even without attorney's fees, but it's usually not that expensive without the attorney's fees. Now, again, I say that on the most basic of estates, okay? The more complicated your estate is, of course, like anything in life, the more expensive it is, okay? The good thing about Virginia has a lot of laws that sort of alleviate the need for a lot of intrusive probate. You know, I compare Virginia to Maryland. Maryland is a little bit more intrusive. I'll call it intrusive. There are more court requirements, more time spent in court in Maryland. DC is sort of an in-between state with respect to the probate process. But I would have to say that of the three jurisdictions, I would think that Virginia is the most, probably the most streamlined. But yes,
I got two questions in the chat room. Let me hit this. Does the commissioner of accounts have power over real estate in an
intestate? In an intestate.
All right, situation. Right. And then the second question, can they require it to be sold if heirs cannot agree?
Well, I'm not sure what they mean by does the commissioner of account have power over the real estate? But what the commissioner of accounts is, the commissioner of accounts has authority over that process, right? So the commissioner of accounts is really there to make sure that the probate proceeds as intended. Now, in intestate, what does that mean? That means that there wasn't a will. Okay, so there was no will at the time of this person's death, or they couldn't find a will. All right, and so that means that the property, and they're talking, the question was about real property. The real property has to pass to the heirs, right? And those heirs are going to be defined by that family situation, right? That person passes. Did they have a spouse? Did they not have a spouse? Did they have children, predeceased children? It can get complicated when identifying who is entitled to shares of that real estate after a person dies intestate. Okay. Now, in Virginia, they have this whole theory of real estate drops like a rock. Okay. And what does that mean? That means basically, once a person dies, their heirs now own that property. Poof, right? It's a little bit different in DC, because in DC you have to have a certain trustee deed or a PR deed to make sure that the property is transferred accordingly. And if it's intestate, then the court can appoint somebody as PR to do that, as executive to do that and do that deed. But that's not required in Virginia. So it's going to drop like a rock. And maybe that goes to what they are asking about, the authority of the commissioner of accounts. But when I look at the commissioner of accounts in Virginia, I sort of look at them as sort of a referee, to make sure that the things that are supposed to be distributed are actually distributed if there's an issue. And if there is some type of fighting, then to bring those parties before the commissioner of accounts to put those issues on the record. Okay. And, when you talk about, I think the other question was about, could you repeat that question? Because that had something to do with the
Does the commissioner of accounts have power over real estate in an interstate situation? And the second part from the same person, can they require it to be sold if heirs cannot agree?
Well, so again, when we talk about if heirs can't agree, I don't want to get into, this sounds like a very specific situation, right? And I see them all the time. So I don't want to give legal advice on that because I don't know the entire situation. But either you're an heir or you're not. There's really no agreement. Okay. So if I have 3 children and I'm single, those are my heirs. Okay. They now own the property. In Virginia, it drops like a rock. Now, you have 3 people who own the property. All right. At that point, whether they can agree on what to do with it, right, is between the 3 of them. All right, but they own the property. So what can you do when you have a parcel of real estate that multiple heirs own, and one wants to build a house on it, the other one wants to keep it vacant, and the other one wants to sell it? You have to sell it. If the 3 owners of or the multiple owners of real estate can't come to some agreement on how to own that together, either one of them has the right to go to court and ask for it to be partitioned. Okay. Now, I don't really know, to be honest with you, in Virginia, if the commissioner of accounts would do that as part of the probate process. That I don't know, because again, if it's intestate, I can't see why the commissioner of accounts would be dealing with the partition, which I see as something that is sort of post probate. But again, I don't want to give legal advice on a situation because there may be some other nuance there that I'm not aware of. But it is not unusual for multiple heirs to end up owning a piece of real estate. Most of us probably have families with that situation. I know we have land in Caroline with probably 50 to 60 owners, right? And you look back in the land records and it's somebody's name from way back, right? But if you go to try to sell it, all of a sudden, the title company saying, well, you got to get signed off from all these other heirs. And we have that issue a lot. Who's paying the taxes? And the person who's paying the taxes thinks that they own the property because we've been paying the taxes. Well, no, you don't. But you may have a right to contribution to get that money back. So again, whether or not the Commissioner of Accounts should be handling that, I think it depends on the situation, but usually a partition situation is outside of the probate process. Okay.
Got another question from the chat room.
Okay.
Many of these forms you can find online.
Mhm.
If you get them notarized, is that okay? And the second part, well, you want to go on and do that first part?
Yeah, let me do the first part. Is it okay? I'm not sure what okay means. Okay. And I say that because the first question has to be like anything.
I think the answer is in the second question.
Okay.
Will it stand up in a court of law, or do you have to go through an attorney?
Well, think of it this way. Does that document do what you want it to do? Okay. So I don't like discouraging people from using forms that are readily available. I think, having a form document is better than having nothing, right? But you have to read it. Okay. Read the form document. Because all of these documents are personal, right? One of the things that Ricardo asked earlier was about, can you write a will in your own hand? Imagine a situation where you have no form, right? But you have a piece of paper, you're dying, and you want to leave property to someone in your family. And you write it out, right? That document is going to say exactly what you want. It's going to identify exactly what you want it to identify. It's going to give the person that you intend exactly what you want, right? A form can never do that, right? A form can never do that. You're always going to have to add or subtract something. So is a form going to stand up in court? Usually, right? But that's not as important as whether or not it's going to do what you want it to do. Because this is really about you. It's not about, the convenience of some machine that has, spit out a form for you. You really want to take a look at, what do I have around the house? I got, my grandmother gave me these coins. I want Susie to get these coins. Okay. So is it going to do what you want it to do? Whether or not it is notarized is not going to, be determinative. Now, you have to have witnesses to your will. And so, having a notary can serve as a witness, right? But the question of whether or not a form document will be valid and stand up in court just because it's notarized may be yes, but it may not get you where you want to be. Okay. So that would be my answer to that is look at the form, ask yourself, what is it that I want to really do? And then see if I can understand whether this does it for me. Because if it doesn't, then I need to talk to somebody. Okay. Okay.
Chip, question for you.
Yeah.
This is very rich, and it looks like we're going to need to do a part 2. Can you go through and I can't pronounce that word, but you're the lawyer, the one you have up right now, Virginia?
Intestate.
Yeah.
Okay, Virginia intestate. So this is a brief summary of Virginia intestate law. What does that mean? What does that mean? That means I died without a will, okay? And I died without a will, and I had property at the time of my passing. I own things, I own stuff, buildings, property, money, etc. Well, who gets what? And that's what the intestate law is about. Who are your heirs? Okay. As opposed to a legatee. What's a legatee? A legatee is when you have a will and you identify who these people are. Okay. But if you have heirs, usually it's because it's intestate, and they just by law are entitled to receive a share. So this goes through, you know, in the first situation, whether you have a spouse, descendants, and a parent. So the first part of this means this person died with the spouse, descendants, and parents. And so the 100% says everything goes to the spouse, or 1/3 to the spouse and 2/3 to the descendants. It should be an issue, if issue or not issue of surviving spouse. It will take me another probably 30 minutes to go through the ifs, ands, or buts here. Use this as a reference. It is, since we're sort of low on time, let me say this. It is not always the case that your spouse gets 100%. Okay, or it's not always the case that this person gets 100%. So in Virginia, you have to understand that when the person passes, you have to take a picture of who survived that person, whether they had a spouse, whether they didn't have a spouse, did they have any descendants? Okay, so for example, in the second one, spouse and descendants only, meaning there's nobody else. Your parents are not there. A spouse and parents only, 100% to the spouse. So if you die, I had a spouse but didn't have any children, I did have parents, the spouse gets everything, right? Now, imagine a situation where the person dies and their parents are alive and the spouse gets everything. Some parents may not be too happy about that, right? But what you see here, and as complicated as it looks to you, right? As complicated as it looks to you, the way you avoid that is by doing a will, okay? So why should I do a will? Because if you don't do a will, the people who are left behind will have to read all of this and decide who gets what, okay? So again, every situation is different, right? When a person passes away, they leave different types of folks behind, okay? And if you leave it up to Virginia law, it's split this way, okay? But if you have a will, you have 3 houses, you leave one house to the youngest kid, you leave another house to the oldest kid, and you order that the other house be sold and give the middle child cash, right? You can do whatever you want to do in the will. That way you don't have to worry about how Virginia dictates how your property will be left. Okay. So yeah, I mean, I have more slides. I know we're getting
Okay.
around the
What
hour.
we'll do, Chip,
Yeah.
we'll get another date for you. I have one more question in the chat room and want to let everyone know we'll do a part 2 with Attorney Richardson. This last, the last question in the chat room is, the will was written 25 years ago and primary beneficiaries are deceased. Do you need to create a new will? And they did say it's probably a no-brainer, but you go ahead and answer it.
I'm sorry. So let me get this straight. The person who wrote the will, the person who did the will, are they still alive?
I don't know, but it says the will was written 25 years ago and primary beneficiaries are deceased. Do you need to create a new will?
Let me assume that the person who wrote the will is still alive. I would say yes. And let me take that back. You can do what they call a codicil, right? So a codicil is—
They are alive. They just put it in chat room.
Okay, okay. You can do a codicil, right? A codicil is basically an amendment, okay? An amendment to that way the will, you want to always try to avoid doing a new will if you can help it, right? Even though you can. You have to destroy the last one, okay? If you really, really want to tear it up, destroy it, make sure it's clear to everybody that you destroyed it, it's not valid, X it out, no good, and do a new one. Or if everything else in the will is fine, and you just need to change those beneficiaries, then you could do, a 1-page amendment called a codicil. And that codicil basically says the same thing. I am this person of sound mind, recognizing that this person has passed, this person has passed, this person's passed. My primary beneficiaries are X or Y and Z. Okay, so that's how you would do it to fix that situation. A one-page document. Do it just like you did a will, though. You have the witnesses witness it, and that should take care of the problem. But yeah, you don't want to just let that hang out. If you can catch it, definitely go ahead and amend the will. Okay.
Attorney Richardson, thank you so very much. I will get with you for another date for part 2. Now you have to remember where you stop. I'll remember all. I'll remember also.
Okay.
But to everyone, tonight was recorded. Our Zoom team will post it. And we thank all of you for tuning in tonight. And if you wish to unmute, I can't even say the word, unmute, and say thank you to Attorney Richardson, he'll be back. You can go ahead and do that. Thank you all.
And thanks, Ricardo. I appreciate it. Thank you all.